Very warm good evening to all. Today's topic is on interim maintenance. This topic is, I feel from my side, very scary sometimes because this may decide the case either in your favor or the opponent litigant's favor. Whenever there is a matrimonial dispute, actually this stage will always come, whether it is Hindu Marriage Act, whether it is 125 CRPC, whether it is CRPC is a Criminal Procedure Code under Section 125, whether it is Domestic Violence Act, Hindu Marriage and Adoption Act, Special Marriage Act, for Parsis, Parsi Act, Christian also there is a act. Now, whenever this interim maintenance is a common factor, it comes before us. I have found it very scary for both sides. So you have to be very careful while drafting the same, while replying the same, and while arguing the same. So we will take a stage by stage how we can utilize the best information given by client. Now see, mark these words. When I'm saying utilize the best information given by the client, why I'm saying you at the session progress, I'll tell you why I'm saying this. The information given by client should be reflected. It must reflect in your application. And if it doesn't reflect, and when the judge puts a question to you and you do not have the answer and it is not mentioned in your application, it actually becomes difficult. I'll give you the simplest example. If you give, there is a child born from this marriage. If you do not give the age, if you do not give the class, that is school which is going, English medium, Hindi medium, whichever medium, vernacular medium, which school going, what is the fees the mother is paying. These all things should reflect whether the child is suffering from any disease, whether the child requires the medication, whether the child is going also for extracurricular activities. This is for child. Now, the main applicant may be a wife, maybe husband also. I will speak from the wife side. Now, because normally it is 99%, it's the wife, the lady is the applicant. When you are making application on behalf of the lady, please remember, if she is educated, then why she is not working? See, in one of my case, I have taken the ground that because she has suffered so much that she was a patient of anemia. She was also having BP. She was also having this sugar. And she was total in depression. And she left her job from another state and came back here because the husband filed divorce. So an educated wife, if not working, then also you should give the reasons for that. If you do not give it reasons, because nowadays even the ladies are, the women are also educated. And the court will tell why they are not working. So you should be able to give reasons also. Now, if your lady applicant is not working, secondly, how many children she has, which school they are going, what is the fee structure, what are other things required for them, extracurricular activities, maybe painting, maybe dancing, maybe skating, wherever they are going, put all the receipts in this. So actually, interim application is one of the most important part of any matrimonial dispute, whether you are for the husband or the wife. Now, this is from the wife side. If I am for the husband, then what precaution I should tell? I should tell that even before the pendency of the matter came, I was paying the regular school fees of the maintenance of the children, or I have given her deposit by way of fixed deposit, some shares, or maybe there is a property in her name from where she is earning the rent. And also you can bring this. See, maintenance access, they do say it travels parallel, but it never like that. It is not never like that. You have to give access from wife side if you are, I'm saying, and if you are for the husband side, you have to give the maintenance. I am the example. I tell my clients, एक ही बच्चा है, please pay the maintenance, please pay the school fees, because आपके झगड़े में बच्चे का नुकसान नहीं होना चाहिए. If every lawyer can say that, actually we will build a society, we will build a nation which is very good. Somebody, we will bring out good citizens. That is the only gift we can give this to nation. So always pay for the school fees, because court will appreciate. I have seen some lawyers, including me, paying for the school fee without any court order. If you do this, trust me, court understand that the man considers the children's education important, and he is a cultured man, he is a family man. You can cover this in your arguments. So while drafting the application, while drafting the reply, you should be very careful. Now next come the arguments. Should you supply a lot of judgments during the arguments? No. One, two, three judgments. One or two of the parent high court. If I'm in the Bombay family court, Pune family court, then Bombay high court. I can give the Madhya Pradesh high court judgment also. I can give Delhi high court judgment also for consideration equally. They are also binding. But parent high court does work. Also, you can give the Supreme Court recent judgments also. But don't give the number of judgments like just a plethora of judgments you just put before the court. You put 20 judgments. No. You can use the judgments language while arguing. See, whenever you go for arguments on behalf of wife, either for the husband, always go with some, read some judgments, take the judgments, but supply one, two, three judgments, not more than five. If at all you want, there is some reason behind that you want particular judgment to be given, it's fine, but not, don't supply all 20 judgments because court does not have time. Because according to the court, interim maintenance does interim maintenance. The court takes time, but not that much that they will read your 20 judgments. And sometime when you supply 20 judgments, the point which is in your application may not be noticed by the court. The point which you argue before the court, I won't say court may miss it, but if you put so much material before the court, it will be actually difficult. So always have a written arguments ready. If the court does not, sometimes the court say, no, no, argue orally, I will jot down on my own. Then you should be ready with the oral arguments. Now, what are the points of arguments? I have seen the best lawyer arguing before the court, and they argue everything. There is cruelty, everything, but they don't not argue what is the age of the child, what is the wife doing, what are her needs, which area she is staying, what is the rent required there, what is the lifestyle the husband is having. See, if husband is having car, which car, which he is having cell phone, which cell phone, it is Apple. If it is 1 lakh plus, mentioned before the court. How many vehicles he has? If you have the access to the passport of the husband, how many foreign trips is making? The level of the style, this is the level, the style in which the husband is residing and living a life. His standard of life should be equal to the wife's standard. That is what the court says in all the judgments also. But then you should be able to bring that. He is roaming in the car, four-wheeler, and the poor wife cannot afford to go into the auto rickshaw also. This, all things you have to bring before the court. These are facts. Also, sometime when you argue completely and they suddenly ask you, what is the age of the child? कौन से क्लास में जा रहा है, कौन सी कक्षा में पढ़ रहा है, and the lawyer goes behind and ask which standard the child is. No, you should be ready with that. It's not your client is answering you, yeah, in whispering in your ear, and then you informing the court. It gives very bad impression. So it is very important whenever you argue in interim maintenance that by either for the husband side or the wife side, please argue with all the facts. Then the law comes. And see, I will also tell you importance of the interim maintenance. Now, interim maintenance is something, if it is on a higher level from wife side, then chances of settlement goes down because she is getting higher maintenance. So the settlement chances goes down because she knows that monthly she is getting 50,000. Why she will settle for 10 lakhs? Because if it is monthly 50,000, just imagine for 3-4 years it will be, she will be covering it. But if she is getting less amount, then there is higher chance of you offering a lump sum amount and getting your client released from this matrimonial discord. So always go for settlement, but think about the amount of maintenance which is there. You have to explain your client. If interim maintenance is higher, you have for husband, you have to tell the client that if it is higher, so you have to offer a good lump sum amount. If you are for the wife and the interim maintenance is very low, in some 10,000 to 20,000, then you have, and the husband, if is not in a government job or in a business, you do not have any access to interim. See, now there is a judgment, Neha Vashir Rajnis, where the income affidavit is brought before the court. But sometimes there also lot of things are not completely before the court. So you cannot find out each and everything. A man may be having 10 accounts, but the wife may be knowing only 3 accounts. So it is very difficult to find out all the rest 7 of accounts, bank accounts. Maybe they sometime buy the property in other relatives' name also. In such kind of conditions, it is actually very difficult. So if there is a less amount awarded as interim maintenance, then the settlement will at a lower strata. So always remember the amount of interim maintenance awarded will decide the final outcome of the matrimonial disputes, final amount, that is permanent alimony. Now, when we speak about permanent alimony, many people feel that permanent alimony is something which can be only asked only at the final stage of divorce. No, it can be asked in the after 24 Hindu marriage that I'm saying, section 24 is awarded. Thereafter also you can file the application at the time of conclusion of trial also, and after even the divorce is granted, section 25 of Hindu Marriage Act is maintainable. It is a very important section. Do read it. So this was all about the interim maintenance. I will pinpoint only at the part of the facts and the application drafting and the reply drafting. These two things are very important because sometimes there are 1 or 2 months dates are given. So the honorable judge will read your application and the reply to it. Okay. Now over to Divya. Divya, can you see the screen? Wait. I will unmute you. Yes, yes. Very old judgment about almost century. You can start.
Okay, ma'am. Thank you. Govardhan Das versus Daudayal on 3rd February 1932. This is a letters patent appeal arising out of an execution proceeding. A simple money decree was passed on 10th February 1915. On 21st March 1923, an application which was in accordance with law, ma'am, there is a cursor, yeah, with law had been filed, one for execution, praying for attachment, and one sale, and one in the alternative for the arrest of the judgment debtor. In the course of the execution proceeding, the parties appear to have come to terms, the judgment debtor agreeing to pay the decretal amount in installments extending over several years, the last date being 15 January 1928. All the installments except the last one were paid. On 10th January 1928, the judgment debtor sent rupees 57 by money order, which was refused by the decree holder, who appears to have claimed rupees 222 in all. The decree holder filed an application for execution on 10th January 1928 for recovery of the balance claimed by attachment and sale of the property of the judgment debtor. He admitted that the last application for execution was for the arrest of the judgment debtor, which had been struck off on 2nd August 1923 on a compromise having been entered into between the parties for the payment of the amount by installments. An objection was taken that the application was barred by Section 48 Civil Procedure Code. The Court of First Instance held that the conduct of the judgment debtor amounted to fraud, which saved limitation. The lower appellate court was inclined to the view that when the compromise was entered into, the judgment debtor honestly intended to pay, and one has proved his bona fides by paying 8 installments. It did not find that one here was fraud committed by him. It, however, held that the original execution case was still pending and the court had the right to reopen it any time and pass fresh orders. On appeal to this court, a learned judge of this court, relying on the case of Lalta Prasad versus Surakumar, AIR 1922, all 145, thought that the action of the judgment debtor in putting off the decree holder from executing his decree at once should be taken as fraud if the result thereof is to bar the execution of the decree under the 12 years rule. He has also pointed out that the subsequent order referred to in section 48 clause 1 subclause B can only be passed within 6 months of the passing of the decree under Article 175 Limitation Act. The first question that arises in this case is whether a compromise can validly entered into an execution proceeding and to be treated as a decree capable of execution. Another question is whether the conduct of the judgment debtor who originally intended to abide by the compromise can be said to amount to fraud because the result of his default is to bar an execution. The third question is whether where a new relief is claimed in an application, it can be treated as one for revival. Another question may be whether the subsequent order referred to in section 48 subsection B clause B can apply to an order accepting such a compromise in an execution proceeding irrespective of any plea of limitation. As these are substantial questions of law of some importance, we direct that this appeal may be laid before the Chief Justice for the consultation of a higher bench. Judgment Suleiman J. This is a judgment debtor's appeal arising out of an execution proceeding. A decree for money was passed on 10th February 1915. While an application for execution dated 21st March 1928 was pending and a warrant for the arrest of the judgment debtor had been issued. The parties entered into a compromise, had a written application, was filed in court on 29th August 1923, signed both by the judgment debtor and the decree holder. They agreed that the decretal amount should be paid in 9 installments spread over 4 years. The 8th installment was to be paid on 15th July 1927, and the whole of the balance due under the decree was to be paid as the 9th installment on 15th January 1928. The court ordered that the parties had come to a compromise and the warrant be cancelled. The judgment debtor paid all the first installments in due time. On 10th January 1928, he sent a money order for rupees 57, which was refused by the decree holder on 16th January 1928, which was endorsement that it was short. On the same date, the decree holder filed the present application for execution claiming rupees 222. The judgment debtor objected that the application was not according to law and that it was time barred. The first court held that the conduct of the judgment debtor amounted to a fraud and the limitation was saved by section 48 subsection 2 civil procedure code. The district judge was inclined to the view that the judgment debtor honestly intended to pay the money and had proved his bona fides by paying 8 installments. He, however, held that the execution file had not been completed in 1923 and was still pending and must have been pending until the amount was paid off in full. He accordingly overruled the objection. On appeal to the High Court, a learned judge of this court hold that the present application could not be treated as a revival of the previous application because the earlier application was based on the original decree and was for the arrest of the judgment debtor, while the latter one was based on the agreement of 1923 and was for execution by attachment. Relying on the authority of Joran versus Mahalil, 1918-40 all 198, he further held that the subsequent order within the meaning of section 48 subsection 1 clause B can be passed by the court only within 6 months of the passing of the decree under Article 175 of Limitation Act and not after. He, however, held that the decree holder was entitled to a cessation of the period of limitation on the ground of fraud. He relied on Lalta Prasad versus Suraj Kumar AIR 1931 all 31 for the view that fraud in section 48 should not be interpreted in a narrow sense and held that any action of a judgment debtor which puts off the decree holder from executing his decree at once should be taken as fraud if the result thereof is to bar the execution of the decree under the 12 years rule. On this finding, he dismissed the appeal Govardhan Das versus Deccan Dayal AIR 1931, all 31. The latter's patent appeal came up for disposal before a bench of which I was a member. The case was referred to a larger bench because it involved questions of law of some importance. One of the questions mentioned in the referring order was whether, when a new relief is claimed in an application for execution, it can be treated as one for the revival of a previous application. The appeal as an appeal must fare on a ground which was neither brought to the notice of the learned single judge of this court, nor was it suggested before the bench which referred the case to us, nor has it been pressed before us on the behalf of the respondent. That ground is that no appeal lay to the High Court at all, and consequently, we cannot interfere with the decree of the district judge in this letter patent appeal. As the point involves a question of jurisdiction, it can be taken up in the letters patent appeal even for the first time. The original decree was one for profits passed by a revenue court under Section 177 of the Old Tenancy Act of 1901. Appeals were allowed from decrees only and not from orders. The controversy was set at rest by the pronouncement of a full bench in Zohia versus Mangulal 1906 28 all 753, where it was held that an order passed in execution by a revenue court was not a decree within the meaning of Section 2 Civil Procedure Code, and that no appeal lay from it to the district judge. Although the decree in this case was passed in 1915, the present application for execution and the order thereon were made after the coming into force of the New Tenancy Act. A right of appeal from an order in execution has been conferred by Section 248, subsection 3, and the appeal lies to the court which can hear an appeal from the decree in the suit. But that section is under the heading Appeals from Order, and its language also makes it clear that the order under Section 47 Civil Procedure Code is merely an order and not a decree. Whether it be treated as laying down a rule of procedure or conferring a substantive right of appeal, the new act applied. The appeal accordingly lay to the district judge, but Section 249 provides that no appeal shall lie from any order passed in appeal. Accordingly, no second appeal lay to the High Court from the order passed by the district judge in the execution appeal before him. The single judge of this court could not but dismiss the appeal before him. Accordingly, we have no power to interfere with the order passed by the district judge on appeal. It is, however, urged before us that the appeal should be treated as a revision. There was room for argument under the Old Tenancy Act that a civil revision could be entertained from an order passed by the district judge, even in a revenue appeal. Such a review is not now possible under the New Tenancy Act. It was pointed out by a bench of which I was a member in Jagdev Singh versus Esho Prasad Singh, AIR 1929, all 735, under Section 264 Tenancy Act. Only selected provisions of the Civil Procedure Code are made applicable to cases under this Act, and List 1, Schedule 2 clearly excludes the provisions of Section 115 Civil Procedure Code. Both Section 264 and the heading in the List 1, Schedule 2, show that Section 115 is not applicable to suits and other proceedings under this Act. As provisions for appeal are to be found in the Act itself, there can be no doubt that the appeal before the district judge was a proceeding under this Act. This conclusion is further strengthened by a language of Section 230, under which the exception is confined to appeal or revision as provided in this Act. It is therefore quite clear that Section 115 Civil Procedure Code is wholly inapplicable to revenue cases and has been entirely replaced by Section 253 of the Act. The High Court has no power to revision outside the scope of the latter section. As pointed out in Jagdev Singh's case, AIR 1929, all 735, the High Court can call for the record of only a subordinate revenue court and revise the order of such subordinate revenue court. According to the definition of revenue court in section 3 subsection 12 of the act, read the section 4 subsection 6 Land Revenue Act, the district judge cannot be a revenue court. It follows that the High Court has no power to revise orders passed by a district judge, however ultra vires, irregular, or illegal it may be. This is an unfortunate result calling for the attention of the legislature. There seems to be no good reason why the legislature should not allow a revision from an order of the district judge passed in a revenue appeal. It was observed in Jagdev Singh's case, AIR 1929, all 735, that if the order passed by the trial court is open to objection, it can be revised. The learned advocate for the respondent contends that it would be anomalous to allow revision from the order of the original revenue court, which has been affirmed by the district judge, when the High Court has no power to interfere with the order of the district judge. But such an anomaly has not stood in the way of permitting revisions under Section 115 Civil Procedure Code, Badami Kaur versus Dinu Rai, 1886, 8 all, 111, and V. Ajaya versus Sita Ramachandra Rao, 1916, 39. 195 section 253 allows a revision from an original revenue court only where an appeal lies to the district judge and therefore contemplates a case where an appeal might have been actually filed. Indeed, if the contrary view were upheld, the result for all practical purposes may be to nullify the provisions of the section. For the High Court may very well decline to entertain a revision when a remedy by way of appeal to the district judge is open and may feel helpless when such an appeal has been filed and disposed of. In cases where the first court acted with illegality of material irregularity and the district judge in appeal rectified that mistake, the High Court would, in the exercise of its discretion, refuse to interfere. If the order of the district judge proceeds on grounds which do not appeal to the High Court, it may, in spite of that order, set aside the order of the first court if it is open to any one of the three objections mentioned in the section. If therefore,
It is a long judgment, very well read.
Yes.
Thank you, Divya. Now move to the legal vocabulary. What Divya read is a total civil judgment. And you must have found so many things from that. Those who are on the civil side, they will understand this judgment better, though it is more than 90 years old, I believe, that judgment is. We'll go to vocabulary. The first word today is the visible hai. The first word is today no table. I have a less of the office staff today. Inclined, that is willing. I'm inclined to grant the privilege of anticipatory bail to the petitioner. See the language. I'm inclined to grant, though it is a judge wording, but inclined is a very nice word. It can be used. The language is more important here. Next is nullify. We all know it. Invalidate. As per the best established legal principle, fraud and justice do not dwell together. See, when you learn word, you don't learn one word. You learn the sentence also with meaning. Do not dwell together. Further, fraud nullifies everything. Fraud सब कुछ invalidate कर देता है. Affront, insult or putting down somebody. Now this is female ferticide is not merely a statutory offense. It is a moral blight and a constitutional affront. Now there are two words here. Moral blight. It is harmful to the values. मतलब, finding a sex of the child who is not born in the womb is not right. It is harmful to society. It's a moral blight. That word is, so two words in one sentence. Next is societal malaise. It is illness, something, discomfort. It's not proper. The meaning is illness, but societal malaise. This quote cannot be oblivious to the larger societal malaise that forms the backdrop of the present case. Hmm? The discomfort, not comfortable, something. Not the proper word is that illness. Oblivious. This is again in the, it was in the previous sentence. Unaware, unmindful, or insensible. The court is not oblivious of the fact that providing such kind of protections and facilities depend upon the economic strength of the state. Yes, state means government, right? Lamented. Now lamented means feeling bad. Now feeling bad, हिंदी में proper word तो नहीं है बुरा लगना, लेकिन the court ने खेद व्यक्त किया. Justice M. Nagaprasanna also lamented that female ferticide is not just a legal offense but a moral blight and affront to the Constitution of India. Complicit, like company is going to complicit. Involving in unlawful activity, you're complicit. The radiologist was also held complicit in the offense as he was found filing misleading paperwork for the said ultrasound scan under the guise of, very commonly it is used, under the guise of, under cover of or pretense, under the guise of the said order, the petitioners herein completed the structures by encroaching upon the park area. Now throttling, the meaning itself is very clear: choking or suffocating. The respondent himself reported the matter to the local police, making it appear that the deceased and her child had died in an accident fire. But the postmortem disclosed that Veena had died of throttling and not on account of burn injury suffered by her. See, postmortem report is so important. We were discussing yesterday. So these were the words for today. Very important part to share this video with others because important words are here. Now, next is very important topic for lifelong. You will be doing legal research. Now, legal research is something which you will keep on doing till you are in this profession. Till date, we have to do. Till date, I also have to do whatever you do, whether it's a legal vocabulary, whether reading judgment, whether you have to apply this. Now, some people feel legal research is only for the court work. Not necessarily. Even if you have to draft a notice, you have to do the legal research, because the legal notice you're going to send will be a base for the case you will be filing on behalf of your client in the future. So when you send notice, you have to be very careful. If you are sending a notice in a matrimonial dispute, you should mention about the Sridhan. You should also mention the date she left left her matrimonial home, or she was thrown out of, whether there is a police complaint, because the court does not allow you to take by surprise. Suddenly you bring some papers. No, it's not like that filmy here. You have to be very careful while drafting a notice also. Now, when I say legal research, there is a lot of questions. How do we do it? Let me tell you, it is one of the easiest thing, and actually very, I would say, you will enjoy it as you keep on doing. The first thing, you can visit the library, because Google is good, but library is library. I have requested everybody to spend at least 1 hour in library at least in a week time, or whenever you go to the court, sit for 10 minutes, just go through the book. One of the person who was attending this has asked me how I should improve my this knowledge. How should I read the judgment? I told her that please start reading. One day you read criminal case, one day you read civil case. Even if you don't have cases, you start reading arbitration. You also start reading the consumer cases. Whatever start reading the judgments. Now people say I can Google and I can read. Yes, you can Google and you can read. But what comes in the your cell phone, uh, that is updates, that is not reading, that is just updates. Supreme Court में आज ये हुआ, High Court में ये हुआ. No, no, no. Nowadays, groups are filled up with all the election things. No, no. That is not something you should do. You should read, actually, you should devote some time for research. And for research, if you can maintain a notebook, it's very good. If you can maintain a legal vocabulary book, it's very good. You can also point out some judgments, write down important judgments, and you may be able to refer that, because, or you can put that in one of the word file. Now, when you say, how do I research? I'll tell you, there are keywords. Suppose you get an accident matter tomorrow, and if you are for the accused, then you have to read at least minimum 10 judgments. If you are from Bombay, Bombay High Court. It may be Goa bench, Kolhapur, Aurangabad, Nagpur. But you read all the judgments which were in Bombay High Court. And also few of the judgments Supreme Court. But High Court judgments will actually help you to analyze the facts, analyze the law, and also to find out what are the questions put by defense in those matters, and also where the objection is taken by the state, that is the public prosecutor. Now, this is very important. If you are filing a DV case, domestic violence case also, what are the prayers you are making? Now, somebody told me, how do I draft the prayers? I have written a drafting book. Vandana will share that in the group also. Now, reading one drafting book will not make a good draftman. You have to keep on reading all the judgments. Now, if you are drafting a domestic violence case, people say, first draft, then you read the judgment. No, no, no. First read the judgments related to your case. If you're for a wife in domestic violence, start reading the judgments from the wife's side. If she has children, from the children and wife side. If she is a sister, mother-in-law, from all that side. If you are also doing the some civil case, find out judgment related to it. If you are in the Nagpur, what is the local municipal laws there? If you are in the Delhi, what are the laws there? If you are appearing for the government, what is the government stand in all these years? If it is a writ petition, then see all the writ petitions of the last 5 years. This is the way. So keywords will be like that. Also, very important part is the law commentary books. This is a constitution book. It is with commentary. Just reading direct will not help you. You have to read through the commentary book. That is where the library comes in picture. Because in library you will find thousands of books. I have visited so many libraries. Nagpur has a good library. The Bombay High Court has a good library. Lot of books, and they update it. And the library people are the best people. They will help you if you are actually voracious reader. So keep going to the library at least for half an hour and start reading the journals, also the All India Reporter. There is the Maharashtra Law Reporter. If you are in the Delhi side, Supreme Court, SCC, there are so many things you can go through that. This is very important. So keywords are very important, but keywords will come from your own case. Now, what will be the keywords? In accident case, you have to read the FIR and the charge sheet. If it is happen at a signal, at a highway, I'm giving an example. There is only a small dash. There is a speed breaker. There is a color of the car, color of the numbers. Whether there was a panchanama, spot panchanama. What has come in the spot panchanama? We discussed the panchana types of panchanama yesterday. Now, accident cases and spot panchanama is very important. From which side a car came, where there were there people around. It's very important. I will give you one example. What you can get through research. I was appearing in 138 check bouncing matter. There were 3 accused. I was appearing for 1 accused. And these 2 accused, other 2 accused were together, and they were in hands in glove with the complainant. So my accused was sidelined. So I had a judgment in my hand with the application. It was before Girgaon Court in Mumbai. There was a lady judge, and this judgment was from, see, I am in Mumbai, Maharashtra. Bombay High Court is my parent High Court here. I still found out a judgment from the Karnataka, I believe, and I gave that judgment where an accused can call another accused in criminal proceeding as his witness. The judge asked me, how does it do it? How do you do it? But I gave the judgment. She kept it for order for others, for the reply to other side. It was order, and let me tell you, I was allowed to call the witness, and that witness came before the court, and I have examined him on behalf of my. So one accused can bring the another accused. If you see, there are cases when accused has a right to remain silent. I think recently I saw while in the flight, Legally Veer one movie, where the lawyer gets up and say, "My client has a right to remain silent. He's right. As per constitution, he's right." You watch that movie. Not everything filmy, but to some extent, there are realistic, and at what extent the lawyer can go to defend somebody, to defend his own client. Good movie, but on the legal side, you can watch it for legal point of view. But here I have called upon another accused as my witness. This is very very rare, and but research took me there, and the judge was impressed. The other side were also taken by surprise, because they said, how can one accused call another accused, because they are on the same side here. If you understand, it was A versus B, C, D. I was for D, and I called the B as a witness for defending my case. So this was something very surprising, but my research took me there. So if you are doing research for your case, it will be help you to get acquittal or conviction, or at least good orders, and at least your client knows that you can do that. And I brought before the situation before the court that these people, complainant and the accused number B and C, I was for D, they were having hands in gloves, and somehow they were actually harassing my client by filing this false case. The matter got settled thereafter, and my client is to pay only his share, not all the shares on behalf of PCD and complete company. So the research is something which can actually take you to the acquittal side, or it can actually turn the tables on the other side. So thank you very much, everybody. Any questions?
Thank you. Madam, very thank you, madam.
Thank
You are
you.
a good lecture.
Thank you, sir.
Thank you,
Thank
madam.
you so much, ma'am.
Thank you.
We are very happy your lecture.
Thank you. From where are you, Manohar Para, sir?
I'm at Hanamkonda, madam. I am retired bank manager. I am doing my final LLB.
Okay.
After retirement, I am doing LLB.
Very
Now
nice.
I'm in final year.
You are you are an inspiration to all of us.
Thank you, madam. From Telangana, Warangal district.
Okay. Nice.
Thank you, madam.
Thank you, ma'am. I'm Kamal from Ghaziabad.
Yes. Thank you. Thank you.
Thank you, ma'am. This session was extremely informative.
Thank you so much, ma'am. Very nice
Thank you,
session.
madam.
Thank you.
Thank you,
Thank
madam.
you so
I am.
much, madam.
Thank you, madam. I am Vijay Kamble from Maharashtra.
Thank you, sir. Thank you, Vijay.
Okay, okay. Thank you, madam. Thank you, madam.
Ma'am, one generic question.
Yes, yes. Tell me. What is the
Ma'am,
question?
see, this whatever the case study which you're saying, right, ma'am? So, is this applicable religion, ma'am?
Applicable to?
Irrespective of the religion?
Depends. If it is a Parsi Act, it's a Christian Act, little bit different. But more or less
Yeah,
the law is same. Hindu marriage act different. For Muslims, it will be different, right?
exactly. So that's the reason I was just
You know,
trying to
it will
say.
be different. But more or less the facts and law is similar. Little
Mhm.
difference, not much.
Yeah, I'm pursuing second sem, ma'am. In this, actually, the family law Muslim is just started actually. So that's the reason. Just
Okay.
want to clarify on that. So, ma'am, while no debating or while we doing the case actually, at that time, can we take this example depending on the scenario, which may be no similar? For example, like the child is studying in a school where we are paying a fees of 100 rupees. Example, 100 rupees,
Yes.
and after divorce, also the person need to pay the same fees for the child. Like that, we can take some of the scenarios and
It
explain
depends
in
on,
the.
see, depends on for whom you are appearing, one. Number two, also the situation, because I had a case where the husband was saying they can study in a municipal school, why they are studying in private school. That is not a way of arguments.
Correct. Because he already studying in a school where he paying 100 rupees. So
Okay.
it should be continued.
he can mention that, but if the wife says that if they can go to better school, why not? It depends on how the case is pursued.
That means if you're saying in that way, then the judge also, it will depend on the judge also actually,
Yeah,
how we
depends
make a
the
decision,
situation,
right?
how you defend also, what is your situation. See, everybody wants to
Hmm.
give best of the education to their children, right?
Correct. Yep.
Okay.
Agree, ma'am. Thank you.
Thank you. Thank you.
Ma'am, I
Ma'am,
have a question.
Thank you, ma'am.
Who is
ma'am,
next?
actually, I want to
My
know
name
that.
is Meenakshi, ma'am.
Let
Yes, ma'am.
her
Ma'am,
handle.
I wanted to ask about what in case if the child cross 18, okay? Because being a single mother,
There is a case if the child crosses 18 still studying. There is a case. Just message me. I'll give you that case. I think it starts from Abhilasha or something like that. I have a that case. If the child crosses 18, I have a case, that case with me.
okay, ma'am, I just want to ask you about the maintenance. Can the child get maintenance after 18 as well?
That's what I'm telling you. I've got a case laws on that. He or she can get the maintenance. I got a case laws. Message
Okay,
me. My number is there. One thing,
okay.
number लिख दो इसमें अपना chat में.
I do have your number, ma'am.
Okay, message.
I'll ping you.
I'll share it tomorrow. I think some
Sure.
Abhipasha
Sounds great.
something is
Sounds great. Thank you, ma'am.
okay.
This side, Ashmita ma'am, the session was extremely insightful. Thank you for your and I want to know that which movie you are referring so I can watch it.
Legally Veer, I think. Legally Veer.
Legally?
Legally Veer.
Legally Veer. Okay,
Message
ma'am.
me. I saw that while coming from the flight in Air India.
Oh,
So it was a little bit long, but good. I found it good. At least,
yeah. Sometimes we found that series also very nice to
yes, yes.
learn.
Yeah.
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 Thank you, ma'am.
Okay.
Hello.
Hello.
Hi, ma'am. My name is Advocate Suresh. I'm from Mumbai.
Okay, Suresh ji. Tell me.
Actually, it is regarding one of my friend through relatives. I came across one case. It's an international crime, check bounce case.
Okay.
He's stuck in Qatar right now.
Okay.
Like he borrowed some money from his friend, and on behalf of that, he gave a check. So the check got bounced. Then complainant gave the complaint. Then he just came out of that country, that complainant. Now that accused is stuck in Qatar from last 1 year.
Okay. You are defending the accused.
Yeah, the accused relatives approached me
Okay.
to
Okay.
help him.
So please record it now.
So what are the chances are there? What steps
Nobody
should
can
be
answer
taken?
that. Nobody can answer that. The best part is you put your best studies in the case. Read all the related. I have a check bouncy cases, old videos also on the
Mm-hmm.
YouTube. Just go through it. There are some judgments which you can go through it. I will mention the judgments
Okay.
also in the description box.
Mm. So initially, what exactly we have to do in this
You have to
case?
research. You have to Suresh ji, you have to research a lot. Depends on very
Research.
research and start. You should prepare your cross examination very thoroughly. You should
Mm-hmm.
also see what are the documents. I don't have a case. I'm just telling on the way the information you shared with me. His complaint and the documents he's tendering in evidence. If you
Mm-hmm.
break his evidence, also see whether check was completely filled by your client
Mm-hmm.
or it has filled by, and also see the liability part also, and read judgments on the section 139.
In the in foreign also the same section will apply. Qatar.
Which country? Acha, you're talking about Qatar.
Yes.
Qatar, I don't know. See, I may not know
This
the
all
basic.
this
I will
actually
not
I'm
know the law. But the
I just
cross examination, everything. I thought it is India and the Qatar client is from Qatar. No, no, no. I may not know the their laws how it is.
yeah, I'm a new to this
But you
field.
will have an
I
opportunity to cross examine, right? So
no
see
no
the
no no.
basics are listen. The basics are same. See his complaint. See the check. Physically examine the check. physically
Hmm.
examine the documents he is producing before the court, and also prepare your cross-examination questions thoroughly. If they allow under their law to cross-examine you.
Actually,
And
the
you also
problem
keep your
is
document. There may be emails also exchanged between the parties if it is international.
no. The problem is all the documents are in Arabic letter, and we don't
You
know Arabic.
then listen, in Qatar, right? You need
Yes.
to get a local lawyer's help also. Somebody who is actually very good in that.
Hmm.
Keep your hopes high.